Greetings, my fellow freedom lovers, sovereign thinkers. Thank you for tuning into the LLT podcast. My name is Craig, transmitting from the beautiful swampy Mangrove, South Florida. And today's date is Friday, March 6, 2020. Yeah, I decided to do something really cool today and just, I know people wigging out. If Joe Biden becomes president, he's going to use Beto O'Rourke, Francis himself, to be the firearm. Supposed to be some potential firearms czar if he decides to run for president, if he gets nominated or wins the presidency. Of course, you got folks out there who are pro-natural laws, firearm rights, all that. They're all getting angry, and it's not too surprising. Well, the bottom line is this: all these rhetoricians are not really that tough. They have everyone else do their dirty work because they're a bunch of palmolivists, dishpan hands. Folks like that don't want to get rugged. They like to point and speak with that pathetic tone of voice they had. Go get him for me, folks. I'm just being sarcastic. It's not to get offended, but be inspired. Because one thing I could tell you, folks, they hate when free people exercise their natural rights. They don't want to see another battle of Athens, Tennessee that happened on August 1st and 2nd, 1946, which is on election fraud. Oh, yeah. Look it up. Great history about that, too, folks. They like to see everyone be enslaved, be house and field peasants. Yeah, boss, everything's great. Oh, the place is like crap. No, boss, everything's all fine. And the fields smells like manure. Oh, it smells great, boss. And I say that ethically. You want us all in the same tyrannical plantation. Maybe Spike Lee has that problem about going to a New York Knicks game. It's just a scratch of a pimple, my friend. They're doing it to every single one of us. They're going to claim that 3 billion people are on the deep state's hit list. And anyone, the critical thinker, people are waking up. Even the late ungrateful Zebro Brzezinski talked about that on one of his functions. I did a show on him when he passed. There was a sampler on that, so check it out, folks. So, of course, some politicians I still want to talk about tougher firearm laws. It doesn't matter if they're Democrat or Republican. You got a bunch of posers out there with these little faction games, but they are under the same thumb, same wing, same bird from two different wings, right? Oh, yeah. That's a fact. The bottom line is, folks, government in Latin means control the mind. When it comes to say natural rights, they hate that with a passion. They call us terrorists, conspiracy theorists, any name they try to throw at us. But you know what? Liberty-minded people always prevail. So, without further ado, we're going to do a little history. A couple things here. Man got from the JPFO, Jews for the Preservation of Firearms Ownership. A little bit old, but you know what? Has a little historical memory to it. This one here came from Richard W. Stevens, which he was the attorney. Did a lot of work with the late, great Aaron Zellman. And I gotta say, he's very good. I read some of the books he helped wrote with Zellman. One's called Death by Gun Control. Very good book. It goes through all sources so you go further. And he personally wrote one called Dial 911 and Die, the police protection myth, with plenty of footnotes, and you could do your research on it. It's incredible what these people have done, and many of us have the opportunity to grasp that knowledge and share it with others. So, this one here is entitled The 6 Things Americans Should Know About the Second Amendment. A real renegade militia being necessary to secure for a free state, the right of the people to keep and bear arms shall not be infringed. Of course, you got a bunch of clowns out there who want to say, oh, he has to control the slaves and the black people and all that. Of course, if you read the original Constitution about free persons and non-free persons, of course, non-free persons from all different walks of life, different ethnic groups, racial groups, backgrounds, etc. However, this is what he has to say here. First, the Second Amendment protects an individual right that existed before the creation of any government. The Declaration of Independence made clear that all human beings are endowed with certain unalienable rights, and that government are created to protect those rights. A, an unalienable right to freedom from harm and the right to self-defense. Both exist before and outside of secular government. 1. The Torah, Exodus chapter 22, verse 2. Talmud, Jewish law set forth in the Talmud states, if someone comes to kill you, arise quickly and kill them. That's from the Talmud, Triacate, Sanhedrin, 1994, or 72a. Yeah, 1942, 72a. The Babylonian Talmud. And of course, the Triacate Baruch, which is 58a, 62b of the Babylonian Talmud. 3. A Roman Catholic doctrine. Christian doctrine has long asserted the right of duty of self-defense. Someone who defends his life is not guilty of murder, even if he is forced to deal with his aggressor a lethal blow. Alright, so see, Catechism of the Catholic Church, 1994, which is sections 263 to 65, citing and quoting from Tom Aquinas. 4. Protestant doctrine. Individual has personal unalienable right to self-defense even against government. Samuel Rutherford, Lex Rex, which came out in 1644. Jesus advised his disciples to arm themselves in view of likely persecution. Luke 22, verse 36. So any of these people that say that they have these particular creeds and they support disarming, restricting your inalienable right to self-defense are nothing more than hypocrites. Jew in name only, Christians in name only, Catholic in name only, Protestant in name only, etc. They're frauds, posers, and minions. Prove me wrong if you dare. B. John Locke's Second Treatise of Government, 1690, aimed at referring Britain's monarchy and parliamentary system and the limiting powers of government, and profoundly influenced the founders and all Western civilization. John Locke explained the civil government properly exists to more effectively protect the rights that all individuals have in the state of nature. The individuals have the right to life, liberty, and property. They give government the power over themselves only to the extent that it better protect those rights. Thomas Jefferson, author of the Declaration of Independence, specifically declared that ideas of John Locke's second treatise were generally approved by the citizens of the United States. Jefferson mandated Locke's second treatise be taught in the University of Virginia. C. Christian religious thinkers such as Samuel Rutherford in Lex Rex 1644 argued that a man's rights come from God. Using biblical principles and examples, they argued against the notion that kings rule by divine right. To be legitimate authorities, all governments must uphold man's rights and do justice. Otherwise, the people owe a lawless and tyrannical ruler no allegiance at all. D. Cicero, Rome's leading orator, had early argued that the right of to self-defense was natural and inborn, and not a creation of the government. The right use weapons was necessary part of the right to self-defense. Any view to the contrary was silly nonsense. That's in the book by Stephen Peach Holbrook, that every man be armed. And you can look it up. It's The Evolution of a Constitutional Right, came out 84, page 17, to be exact. E, the right to keep and bear arms simply implements an inalienable right to the individual self-defense and against aggression of any kind. The Second Amendment refers to the right of the people, not the state, as a pre-existing right that government must respect. F, the United States Supreme Court in the United States versus Verdugo Eucrates. No, wait. Yeah, okay. Indicate that the word people in the Second Amendment refer to individual, not to states. That case came out in 1990. This was not holding or ruling of law, but an observation by the court. Second, the language of the Second Amendment prohibits the federal government from infringing on the rights of the people. There is nothing ambiguous about shall not be infringed. See Webster's New Universal Abridged Dictionary, second edition, page 941. The language of the Second Amendment is about clear as the First Amendment, prohibiting Congress from infringing the right to freedom of speech, press, and religious expression. There is no logical reason to read the Second Amendment was a weak statement, while treating the First Amendment was a strong protector of rights. A, the Second Amendment protects a fundamental right and should be read broadly because it implements the right of self-defense. Self-defense is ultimate right of all individuals to preserve life. The rights to a free press, free speech, assembly, and religion are extremely important, but none of them matters very much if you can't defend your own life against aggression. None of them matters very much when an evil government is fully armed and the citizens are disarmed. Article 1, Section 8, Clause 15 and 16 of the Constitution refers to Congress's power concerning the state's militias. Clause 15 empowers Congress to call forth the state militias into national service for specific purposes. Clause 16 empowers Congress to organize, arm, and discipline the state militias and to govern the militia while they are in the national service. The Second Amendment confines Congress's power by guaranteeing that the Congress cannot govern the militia right out of existence, thereby disarm the people. So hopefully all you folks in there that supports these individuals that want tougher firearm laws are contradicting their oath of office just by that alone. And you still want these clowns in there? You just breached your own oath as a voter. Third, the Second Amendment refers to well-regulated militia. The right of the people to form citizen militias was unquestioned by the founders. A. Federalist Papers 28. Alexander Hamilton expressed that when government betrays the people by amassing too much power and becoming tyrannical, the people have no choice but to exercise the original right of self-defense, to fight the government. That's from Holbrook, page 67. Federalist Papers number 29, Alexander Hamilton explained that an armed citizenry was best and the only real defense, a standing army, becoming large and oppressive. Federalist Papers 46, James Madison contended that the ultimate authority resides in the people, that the federal government got too powerful and overstepped its authority, then the people would develop plans of resistance and resort to arms. D. There was no National Guard, and the founders opposed anything but a very small national militia. The phrase well-regulated means well-trained and disciplined, not regulated. As we understand that term in the modern sense of bureaucratic regulation, the meaning still can be found in an unabridged in the unabridged Oxford's English Dictionary. Volume 13, page 524, and Volume 20, page 138. Interesting there, second edition. E. The Federalists promised that state governments, citizen militias would exist to make sure federal military never became large or oppressive. To say that the National Guard replaces the notion of a militia runs contrary to what the founders said and wrote. So, in other words, it's irrelevant. But they like the propaganda machine. If you watch those trailers about the militia and the National Guard, it's a fantasy, folks, a phantom fiction. And I'm not knocking the people in the National Guard, but the way they portray it is totally deceptive. And it says here, F, the Third Amendment expressly restrains the federal government from building a standing army and infiltrating among the people, and at the people's expense in times of peace. The Third Amendment runs against the idea of a permanent standing army or federalized National Guard in principle, if not by its words. Fourth, the Second Amendment begins with the phrase, "a real brigade militia," necessary to the security of a free state. The people argue that this phrase limits the right to keep and bear arms to militias only, which they said means the National Guard. The very recent research shows, however, that it was the style of writing legal documents in the late 1700s to include a preamble. The Constitution has a preamble. The Bill of Rights has a preamble. Yet people don't argue that the Constitution is limited by the preamble. Professor Eugene Volokh at the UCLA Law School had examined numerous other state constitutions of the same general time period and observed this kind of preamble language in many of them commonplace Second Amendment 73. So it's like from my revision 793 to 821. The preamble states a purpose, not a limitation on the language in these government charters. Example. New Hampshire's Constitution in 1784 contained a preamble for the freedom of the press. The liberty of the press is essential to the security of freedom in the state, and ought, therefore, be inviolably preserved. Rhode Island's 1842 state constitution recited a preamble, its declaration of the right of free speech and press. The liberty of the press being essential to the security of freedom in the state, any person may publish his sentiments on any subject being responsible for the abuse of that liberty. That means you don't harass people. You don't conscript on others, violate their space. Remember, liberty means freedom plus morality. The New Hampshire Constitution in 1784 also contained a detailed preamble and explanation of purpose for its right to a criminal trial in the vicinity where the crime occurred. Interesting there. And the Massachusetts Constitution of 1780, the 1784 New Hampshire Constitution, the 1786 Vermont Constitution all contain preambles, explanation of the right of freedom of speech and debates in the state legislatures. The New Hampshire Constitution also gave an explanation right in the text for why there should be no ex post facto laws. Okay? Interesting there, because if you read other state constitutions, including Florida's, believe it or not, Article 1, Section 10 talks about that. No bill of attainder or ex post facto law will be part of the contract. So if you see some of these laws that violate your own state constitution, even the U.S. Constitution, under Article 1, Sections 9 and 10 of the U.S. Constitution, any of those laws are void, valid, unacceptable. But people like Joe Biden, Beto O'Rourke, and many clowns like Flip-Flopper Scott and Marco Rubio don't want you to know that. But you know what? Who the hell cares? I'll teach you this. B. The Second Amendment falls right with the style of legal drafting of the late 1700s. The militia clauses emphasizes the individual right to keep and bear arms by explaining one of the most important purposes. The militia clause does not limit the right. Fifth, before the Civil War and the 14th Amendment, many states enacted laws made it illegal for slaves and for free black people to possess firearms unless they had their master's permission or government approval. And of course, there's a review on here, Grandpa Jack number 4. And there's a great video to check out too, No Guns for Negroes, from the JPFO's website. So I encourage you guys to check it out. I have posted stuff in the past, and it's good to know these things, okay? So, when people get dumbfounded, they wig out, they got some races and all that. When I share something like that on my page, you're like, what? I'm like, exactly. This is why I have a different mindset from others. So I'm going to continue on here. A, the Second Amendment did not protect black people then because, 1, it was understood limited the federal government's power, and 2, black people were not considered citizens whose rights deserved to be protected. This is from Dred Scott's decision in 1857, which Judge Terry observed that if blacks had the privilege and immunities of citizenship, they would be able to freely possess and carry firearms, unthinkable to Southern slave owners. Yeah, so that's what I'm saying. That something like that is unacceptable. So, like I said, so you're always going to have those tyrannical mindsets, which I always condemn. So I'm very, when it comes to tyranny, I call it all out. It doesn't matter where it comes from. And it says here, B, the Second Amendment was designed by the people who did not want to become slaves to their government. They were unfortunately and tragically willing to permit private slavery in some states. Now that slavery is abolished, however, all citizens of all races should enjoy the Second Amendment's legal protection against despotic government. And I agree completely. 6. The federal courts of appeal have held that the Second Amendment does not confer an individual right, but only a collective right of states to form a militia. The federal court division in the United States versus Miller as president. In 1939 Supreme Court case, United States versus Miller, did not make that ruling. Even in Miller, where only the presentation filed a brief and the defendant's position was not even briefed or argued to the court. The Supreme Court held that the federal government could only regulate firearms that had no military purpose. That was in the case in 1939. And you can look at that special report on that. And it says here, nowadays, gun prohibitionists want to legalize firearms unless they have sporting purpose. The sporting purpose idea was part of the Nazi weapon law of 1938. JPFO has shown that the U.S. Gun Control Act of 1968 imported much of its organization content and phrasing for the Nazi weapon law. All right. B, in the contrast, even under U.S. versus Miller, the Second Amendment protects the individual right to keep and bear military firearms. Learn how can be trusted. Lower court interpositions of the United States versus Miller and the Second Amendment 26 Second Amendment 26 Cumberland Law Review 961 to 1040. This is 1996. See, a federal judge recently struck down a federal gun control law, a state, about as unconstitutional in the United States versus Emerson, which that case was in North District, Texas, 1999. In his scholarly written opinion, District Judge Cummings extensively reviewed the law and historical foundation of the Second Amendment to conclude that the right to keep and bear arms protected by the Second Amendment is an individual right. The Emerson decision remains pending on appeal in the Fifth Circuit of his date. I'm about to find out if that's been honored or not. Before a government can become full-blown tyranny, the government must first disarm its citizens. The founder of this nation, from their own experience, know that when government goes bad, liberty evaporates and people die unless the people are armed. Challenge to Americans as you read the Constitution and Bill of Rights. 1. Look at the enumerated powers of the federal government. 2. Look at the express limitations on federal power as set forth in the 2nd, 9th, and 10th Amendments. 3. Ask yourself, where does the federal government get any power at all to regulate firearms? 4. Ask yourself, why don't the high school and college textbooks devote any time to the library, philosophical basis, and practical meanings of the Second Amendment? And then, consider the law students and future lawyers likewise have received precious little education about the Second Amendment. Realize that the judges know just about a little. Then imagine how little the average American knows, based on the average public school coverage of the Constitution. The protection of our sacred right of self-defense against both petty criminals and oppressive government, the right of civilians to keep and bear arms, is in your hands. And that is true, my friends. That's why a person like myself always like to put that in perspective. Individual right, regardless of race, color, creed, etc. A lot of great history out there, my friends, on this. And if you study how gun control is the role of genocide and democide, 170 million people died on the genocidal chart. They say 270 million died in democidal. According to Death by Government, if I'm correct, by R.J. Rummel. There's a documentary from the JPFO that was done by the late, great Aaron Zellman, Innocence Betrayed. Hardcore stuff to get people to think. Even those groups of March for Our Lives and Mom Demand Act don't want you to know this. Police chiefs don't want you to know. Guys like Sheriff Scott Israel, these federalized sheriffs, they want you to be numbered. They don't want you to go, yes, master, may I have another? I say to hell with them. Because the truth of the matter is, folks, they need us more we need them. That's why we have the thing called checks and balances. Any federal law, you can nullify. There's even affirmations of civil rights. They have one in Broward County. Red flag laws. Totally null and void. Called prohibited laws. Many of it's in our state constitution, including Florida's. They don't want you to know these things. Who the hell cares what they think? I want to teach you guys. Many of you out there who followed me for all these years, I thank you. You got any money, but it's okay. I got to do a donation jar soon, just for fun. However, all these areas here is essential. And it has to be implemented. If we don't, in due time, we'll all become slaves in the technocratic plantation to the core. We'll do one more here. This just came from Neil Smith. Actually, it was out on February 24th. Tribute to L. Neil Smith, the Libertarian Enterprise. I got it from the JPFO website as well. I will put these on my footnotes. And Stop and Frisk is called. As it reads here, the first 10 amendments to the United States Constitution, commonly known as the Bill of Rights, is the highest law of the land. If for some reason you happen to disagree with me about that, probably because of your public education. And with the Founding Fathers of the Supreme Court, there's no point in your reading further. Put it cybernetically, the Bill of Rights is the basic operating system of the country and the sole source of American exceptionalism. If we don't have that, we have nothing. We might as well be Belgium. The second of those amendments famously maintained that the government may not interfere even in the slightest with an individual right to own and carry weapons. lesser lights than the founders over the centuries, have been absolutely terrified at the idea of a well-armed populace. Your people, sir, are a great beast, said Alexander Hamilton, and have attempted desperately to limit that right and gradually will it away. A la concealed weapons permits. Ring a bell, folks? Fingerprints? Get permission? Call it a privilege? Yeah, they use that in the Florida Constitution. You have the right to keep your arms, shall not be infringed, but it can be regulated. Yeah, talk about double standards. The most pertinent and obnoxious example of that, only one of many, is the 1911 New York Sullivan Law, named after the infamously corrupt Tammany Hall. Look it up, politician, meant to primarily disarm Italian immigrants that politicians were frightened by. The law was so egregious that even notorious gun grabber Wyatt Earp questioned Sullivan's mental health. Yeah, Wyatt Earp. Remember that movie Tombstone? Oh yeah, he was a gun grabber too. Want to be a slave master. And it's funny about that because they went after the Italians, they went after the blacks and the Jews. It's cute about that because I threw that question to Rudy Giuliani. He was down here running for president in 2007. He couldn't answer it. He didn't like it at all. But it's funny. I know I got barred when he came down at the FIU to speak in 2008. I was honored. All right, I'm going to continue on here. The act pretended to provide a legal path to obtaining, owning, and carrying guns, but in practice virtually stripped New Yorkers of their rights and means to self-defense. Since criminals, by definition, do not obey laws, the city was well on its way to becoming one of the most violent places in America. Today, if you want to own a carry gun in New York, you need a good lawyer and a powerful political connections. Just the opposite of what the anti-elitist founders intended. Let me restate that. So, can be no mistake about what I'm saying. New York's notorious violent crime problem is a direct and viable result of unconstitutional gun control laws. Read the amendment. There can be no such thing as a constitutional gun law, just as there can be no such thing as an illegal gun. Beginning with the 1911 Sullivan Act. Yeah, you can say like Jim Crow on steroids. Yeah, absolutely. True, some courts have ruled otherwise over the years. They are wrong and usually operate on the basis of historical, political, or linguistic ignorance. In the amendment, regulated, for example, in the 18th century, meant guns that all use the same size bullet. And I hear these clowns talk to me like that all the time. This is what thus it was that the Big Apple, which should be the most civilized city in world history, became the third world toilet that is today, the playground for a half dozen different varieties of mafia, Italian, Colombian, Russian, etc., and a free fire zone for criminal gangs. Drug prohibition doesn't help, just as alcohol prohibition launched the mob as we know it today. My mother used to tell me, 2 wrongs don't make a right, and your mother probably told you the same thing. In fact, they make an even greater wrong. And so the great city's administrative sub-geniuses, aghast at the squalid mess their class had deposited on the sidewalk by abrogating the Second Amendment, decided in the utter absence of wisdom to clean it up by abrogating the Fourth. They authorized the police to conduct stop and frisk procedures, meaning that an individual could be shaken down on the streets if some cop thought or claimed that he had thought he might be carrying a gun. The Fourth Amendment maintains the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. But remember, you got the clowns in these environments believe they're smarter than everybody else. The fudge word, of course, is unreasonable. What in the hallowed name of Noah Webster does that mean? Whatever some gaggle of tin pot dictators, including cops and cherry-picked, ignorant, illiterate judges, what it to mean? I blame the founders for this. I smell Hamilton in the woodpile somewhere, as I do historically tragic error they made by not providing severe punishment for government officials who violate the Bill of Rights. But concede this, how can you lawfully or even logically search people for illegal weapons when under the Second Amendment there's no such thing? And even if you could, where the bloody hell is there warrant specifically describing the place to be searched and the persons or things to be seized? Former Mayor Giuliani rushed up this particular dog's breakfast to Douche Michael Bloomberg, although he is not now apologizing for it. Let it continue when he was mayor. Crime dropped a bit in New York under the stop and frisk the same way it would if the cops broke everybody's arms. Now it's politically incorrect. Remains illegal as hell no matter what some bought and paid for judges proclaim. So my message for the entire Putrid collection of ward healers and those in Chicago and Californistan as well is to seize both unconstitutional practices immediately, respect and enforce the Bill of Rights. It is or ought to be the politicians' 10 Commandments. Wait until somebody actually commits a crime. Carrying a gun is not one of them, according to James Madison. Before you decide to throw him up against the wall, and above all, rely on the people and end, at minimum, a 380 auto or a 38 special in every pocket or purse to clean up your crappy town. Can't refute that. Because the fact is this, my friends. Technically, the police aren't obligated to protect you as an individual. I try to write to people like Bloomberg and other bobblehead politicians out there to prove me wrong. They couldn't. You don't need a Supreme Court case to look it up. All you got to do is look at your state laws. Sovereign immunity, tort liability. Just look that up. They give you all the information pertaining to that from almost every state in the union. Court cases as well. This is why, when it comes to the first line defense, you, the individual, that's your obligation. And we do have duties on preserving our natural rights, with no exceptions. Don't let these douchebags, bobblehead politicians tell you any different, whether from federal, state, or local. When they do, they're your enemy. They hate basic rights. They hate your right to natural law. Those are the ones you gotta despise and call out instead of licking their shoes and being, oh, he's such a nice person. Regardless, if you violate one person's rights, it's a violation to us all, and that's a fact. May the truth shall set you free, and if you're your enemies. And you know what? I get inspired by that. And that is it. I thank everyone for listening. Plus, feel free to download and share it throughout your social media networks. If you have any questions, comments, or you want to give me something that's interesting you want to check out, whatever you do, please feel free to send your correspondence to the quorum. I will leave these 2 articles on my footnotes. And you can hit the JPFO's website as well, jpfo.org. You can look up No Guns for Negroes, No Guns for Jews, and Second Amendment. All you got to do is just go on that website. It's fantastic. And even though it's a little bit different, there's some controversies that was being run by the Second Amendment Foundation. However, the archive is still good. They're still trying to pursue that mindset. So always remain vigilant. And I'd like to thank Stash, which is located at 109 Southwest 2nd Avenue in the heart of Fort Lauderdale, Florida. It's Jansen with Revolution Live in America's Backyard. I should have said that in the beginning. Once again, thank you for your time. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love. And may your guardian spirits be with you.